Welcome, Dr. Lovepreet. Welcome to India.
Hello, good morning, ma'am. How are
A
you?
good and a good evening to you. We appreciate the time that you have taken out to address the participants for this international capacity building program. So I
Thank
think,
you. Thank you so much, ma'am.
okay,
Thank you for
Lovepreet, do
the
you?
yeah,
Uh,
thank you so much for the invitation. Yeah.
okay. Do you have a PPT to share?
Yes, ma'am.
Okay. Mr. Monjit, kindly make her the co-host so that she can share her PPT.
Okay, so I think I can see this message on the screen that I am the co-host. I'll try sharing the screen. Uh, if anyone can please let me know if the screen is visible.
It
Yes,
is.
ma'am. Yes.
Okay, thank you so much. Okay, I can just zoom this out a bit. If that's helpful. Okay, I think that's good.
I think we are we good to begin? Is a heads up from you, Dr. Lovepreet?
Yes, ma'am. I'm
All
good.
right. Okay. Over to Mr. Gursandesh and Dr. Gaurav for the session today. They are the session in charge.
Thank you, ma'am. Thank you. Good morning, everyone. Welcome to the second day of the International Capacity Building Program on Gender and Cultural Studies, Pedagogy and Research. So, on the second day, today we have with us Dr. Lovepreet Kaur, uh, the expert with us today. Um, Dr. Lovepreet Kaur is the Investigations Manager at Brock University, Canada. She is a legal and equity professional with extensive multidisciplinary experience in human rights, academic research, policy development, and equity advising across public, academic, and legal sectors. She holds a PhD in law with a focus on human rights and gender justice from the Rajiv Gandhi National University of Law, Punjab, where she also earned her Master of Laws with distinction, securing the first position and graduating as the university gold medalist for academic excellence and receiving 4 gold medals. She also holds an honors Bachelor of Arts in Political Science and Bachelor of Laws with distinction from Punjab University, Chandigarh. Before joining Brock University as its investigation manager, she served as a faculty lecturer at the Faculty of Social Sciences at Brock University and as a sessional instructor at the University of Guelph. Her recent experience includes her roles as the Diversity, Equity, and Inclusion Advisor in the municipal sector, Research Fellow at Osgood Hall Law School, and the Center for Feminist Research at York University, and as Assistant Professor of Law at the Rajiv Gandhi National University of Law. Uh, Her session today will focus on gender and law, and I welcome you, ma'am, and
Thank you
I
so
request
much,
you.
sir, for the introduction. Thank you so much. And I think I can take it on from here. Okay, so once again, thank you so much, ma'am, and thank you so much for inviting me for this session. And as sir has mentioned, the topic of our today's discussion is going to revolve around this very important topic, gender and law. So, as I have planned today's session, I'll just move on to our next slides that is going to give you a bit of an overview of what this sort of session is going to look like, what is going to be our intakes, what is going to be the things that we are going to learn from this session. So our today's discussion is going to be around gender and law, and we are going to focus on gender and law as a critical area of legal inquiry and practice, rather than we are treating gender as a narrow, or I would say an isolated issue. This discussion is going to position, I would say, gender as a structural lens through which we can better understand sort of how law operates in society. And we begin and then we'll begin to sort of clarifying that what we mean by gender and law and why this field itself has become central to contemporary legal thinking. So, after discussing that, we will then examine looking at the legal systems, like how legal systems they often presented as neutral and objective, and they can actively, what I can say, construct and sustain gender inequality. And this includes looking at the ways laws are drafted, looking at the ways that how laws are interpreted, and very importantly, how laws are going to be enforced in a society. And very importantly, when we say enforced, we also need to focus on like how they interact with social norms, how they interact with power relations. And following this, I will then focus on some key feminist legal approaches that scholars and even courts they have used to critique the traditional legal frameworks, and then also they are going to sort of propose more inclusive alternatives, right? And overall this session will going to apply these ideas sort of across major legal fields, and we'll also talk about how gender and law is sort of making its emphasis on employment law, family law, criminal law, constitutional law, using sort of some illustrative examples. And overall this will we will reflect on the contemporary debates as well, and I have sort of put in some discussion points around LGBTQ plus legal recognition and even cultural tradition to sort of encourage the critical engagement with current gender justice challenges in India. So overall the discussion itself is going to, I would say, is not just going to inform but to sort of build the analytical capacity and practical understanding around this topic of gender and law, right? So, if I have to briefly say what is the desired, I would say, the end of this session, what the participants will be able to achieve from this discussion. So, if I have to say around that, so by the end of this session, I would say that you would have an understanding or you'll be able to grasp the foundational concepts that define the field of gender and law. And this sort of includes the understanding about how gender functions as a legal and social category, and how it influences the design and impact of legal rules. A key outcome, if I would say that a key outcome is the ability to distinguish between the two important concepts, that what is formal equality that focuses on treating everyone the same, and then there is coming the other concept of substantive equality, that is which seeks to address the real world advantages and unequal starting points of an individuals. So you would be able to identify the gender biases within the legal system even when laws appear neutral on their face. This is very difficult thing to comment and debate on when we say like gender neutral laws are the best. They are going to govern the society in a good way. But even there are some laws that appear neutral on the face, they also have some persistent gender biases within the legal system. I'll delve deeper on this topic in our discussion. So this involves recognizing the implicit assumptions that are embedded in our legal standards, in our procedures, in our institutional practices. And another important outcome, sort of from our discussion, is going to be developing the ability to apply the very important thing, intersectional lens. The intersectional lens is about understanding that gender itself does not going to operate in isolation, but gender is going to intersect with different spheres. And when I say different spheres, I am referring to gender intersecting with caste, gender intersecting with class, with religion, with race, sexuality, and other social identities. And overall, this session itself is going to give you an understanding of to critically engage with ongoing gender debates, whether in courts, even in policymaking, even academia, or in our everyday governance. This means we are going to ask the informed questions about who benefits from the laws, whose experience are excluded in the law, and how legal reform can move towards genuine equality, right? That is sort of the discussion that I've just given you an overview of what our this whole discussion is going to look like, what we aim to achieve from our session. So now I'll move on to the next slide that talks about what is gender and law and why gender matters in law. So, talking about the first part of this question, that what is gender and law? So, in there, these two terms, gender and law. Gender and law itself, if I have to like sum up in my words, it's a field that examines the relationship between legal systems and gendered social realities. And when I say that, at its core, it asks that how law regulates the gender roles. And when I say gender roles, that means the expectations around caregiving, very basic gender role. When we say gender role, that's the first thing that comes into our mind. Expectations around caregiving responsibilities, around work, around family life, and how these regulations sort of affect people differently. And law does not simply respond to society, it actively shapes the social norms by defining rights, by defining duties, and also by defining what is called an acceptable behavior in the society. And this field of gender and law, it also highlights that how legal systems can reproduce inequality, even when there are laws, even when discrimination is not explicitly stated. Let's say, for example, there are laws. We have a law that says that assume a full-time full-time role, or it's what we can call as full-time uninterrupted responsibility work trajectory that tend to favor those who do not bear disproportionate caregiving responsibilities. And historically, the first thing that comes into our mind, it is that it is more men oriented because they do not bear the caregiving responsibilities, and this is more sort of focused on their role, on their responsibilities. In this way, when we say that it focuses on their role, then law can itself reinforces that patriarchal mindset, that existing hierarchies, rather than dismantling them with the implementation of laws. And this concept of gender and law in this situation, it can further explores that how power operates through legal rules, through institutions and courts, legislatures, and even the third thing, very important, the enforcement bodies. They are not neutral spaces. They are shaped by historical power relations, even dominant social values. And what the feminist legal scholars in historical time, what they are doing, feminist legal scholars, they challenge this sort of myth that law is purely objective by showing that many legal standards, it reflects the male's experience at the norms. So importantly, this field of gender and law, it moves gender away from being seen as merely a women's issue and then reframes it as a structural question about how law or how legal systems allocate power, how legal systems provide resources and recognition. in the society to an individual, moving away from this patriarchal mindset. And then if I'll be talking about the second part of this question around why gender matters in the law. So in this slide, I've mentioned about gender shapes access to employment, family rights, justice systems, bodily autonomy. So just to expand on these pointers, gender itself matters in law because it fundamentally shapes people's access to rights. It shapes their access to opportunities and even justice. In employment, in this point, gender influences who gets hired, who gets promoted, who gets paid fairly, even who performs unpaid care work that remains legally undervalued, I would say. In family law itself, gender affects the expectations around marriage, around caregiving, around custody, around financial responsibility. Often, even if we are saying that we are all having the gender neutral laws, it often placing the disproportionate burdens on women. In justice system, talking about this point, gender shapes like how individuals they experience policing, courts, legal remedies. And survivors of gender-based violence, for example, if I have to give, may face disbelief, they may face stigma, or they also face the procedural barriers that even discourage them from reporting the incident in the first place, right? And then talking about the point about bodily autonomy, especially this bodily autonomy thing in relation to reproductive rights and sexuality, it is another area where law itself deeply intersects with gendered control, with social norms in this area of reproductive rights and sexuality. And the critical insights from feminist legal theories, the legal theories that we're going to talk in our next slides, the upcoming slides. The feminist legal theory is that the gender neutral laws can produce unequal outcomes. And when I say the gender neutral laws, it means that when laws apply the same rule to everyone without considering social realities. So, if there is this one legal rule that is equally going to be applicable to all the genders, irrespective of their social realities, they may reinforce the existing disadvantage. For instance, here, if we have a workplace policy that offers no flexibility, that may disproportionately harm women who carry the primary caregiving responsibilities, even though we can say that this is a rule and everybody is going to follow that rule because it is a gender neutral rule. But that is going to disproportionately harm this particular gender, whose primary role is to provide the caregiving responsibilities. And finally, if law operates within the broader social, cultural power structures, that includes patriarchy, that includes tradition, that includes economic inequality, then ignoring these contexts, it can make law reform ineffective, or I would say even harmful. So understanding this concept of gender in law, it and specifically gender, it allows us to see that how law can either challenge inequality, or I don't want to say that, but quietly sustain it, right? So moving on to our next slide, that is about the feminist legal frameworks. Herein, I'll be talking about different feminist legal scholars and the theories given by them in relation to our discussion today. So, under this, to understand, I just thought that I'll create this slide and these theories because this is going to be helpful for us to understand the gender and law more deeply. So, feminist legal scholars, they have developed these analytical frameworks that helps us evaluate like how legal system operates. And these frameworks, they do not all agree with one another, but together they sort of reveals different dimensions of gender inequality. And the most influential approaches that includes these pointers: the formal equality, substantive equality, non-subordination or dominance theory, different voice theory, and intersectional or postmodern feminism. So I'll talk about each of these pointers one by one. So at first, I have mentioned here the formal equality. So I have briefly talked about this very point at the beginning of my discussion, wherein I have talked about like by the end of our discussion today, we'll get an understanding of difference between formal equality and substantive equality. So this term, formal equality, as I mentioned, it focuses on treating everyone the same under the law. While this term substantive equality, it recognizes that identical treatment can reinforce inequality when social conditions, when starting points are different, are unequal. And this non-subordination theory, it shifts the attention to power and dominance. And when I say that it shifts the attention to power and dominance, it argues that gender inequality is structural rather than accidental. And this different voice theory emphasizes the lived experience. It emphasizes the care. It emphasizes the relational reasoning in the society. And this another concept of intersectional feminism. It critiques that the formal equality approach, I would say that. And this intersectional feminism, they critiques the one size fit all approach, and they insist that gender must be analyzed alongside the other intersectional spheres, that being the caste, class, race, religion, sexuality of an individual, that should also be analyzed alongside the gender of an individual. So all these frameworks, all these theories given by feminist legal scholars, they help us understand, they help us ask questions about who this law is designed for, whose experiences are being prioritized, and very importantly, whose realities are going to be ignored in the making of laws, right? So, in the upcoming slides, I'll be focusing on each of these feminist legal frameworks. So, first one being the formal equality versus substantive equality. So, herein, I have tried to correlate some of the concepts with our Indian legal structure, Indian legal framework. So, formal equality is based on that the principle of fairness, I would say. The principle that means treating everyone the same. So, under this approach, the law itself explicitly make the distinction, and, for example, applying the law same equal to all the genders. And Article 14 here, as an example of the Indian Constitution that guarantees equality before law. And early gender equality, if I had to say, that struggles, the focuses focused on eliminating the overtly discriminatory provisions. However, This formal equality thing assumes that everyone began from the same social position. But in reality, women and gender diverse individuals, the LGBTQ plus community, they often start from positions that are shaped by economic dependence. The position of women, assuming are being primarily responsible for unpaid care work and have social expectation associated with their gender. And as a result of that, this equal rules can lead to unequal outcomes in the society. But on the face of it, we say that we are having this law, and this is going to do justice in the society because we have explicitly mentioned that equality before the law, and everyone is going to be treated same equally in the eyes of law. So we have this gender neutral law which is going to favor all the genders. The other point about substantive equality that addresses, I would say, this limitation by focuses on the focus is on outcomes rather than identical treatment giving to the individuals. So it recognizes that differential treatment, it may be necessary to achieve the real equality. And then comes into picture the Article 15(3) of Indian Constitution, which allows special provisions for women, reflecting this approach of substantive equality. And examples includes the maternity benefits, the reservation, the workplace protections, and the legislation associated with this article, and legislation implemented on the basis of this specific article. So the useful way to explain this is to say that formal equality asks that are the rules same, while the substantive equality asks that do the rules actually produce fairness in real life. So this is like, if I have to sum up our discussion in one word, if I have to sum up our discussion in these questions around this slide, right? Okay, so now I will jump on to our next slide that talks about the non-subordination theory, different voice theory, and important topic around intersectionality. So talking about this non-subordination or dominance theory. So this theory was developed by the feminist legal scholar Catherine McKinnon. So Catherine McKinnon is the associated with scholars. She is the scholar that who worked on this theory and argues that gender inequality is not simply about unequal treatment, but it is about systemic power imbalance. And according to this view, law often reflects male dominance and treat it as natural or neutral. Sexual harassment law is a key example because what was once considered the I would say the uh, I would say that considered or not being objectioned or not being questioned upon, but now it is recognized as a form of abuse. Because earlier, when we do not have a specific law that is prohibiting such conduct, that is at that point in time, it was questioned, it was objectioned, but there is no law to punish the perpetrator in such situation. But now it has been recognized as a form of abuse. Talking about this other point around different voice theory, and that was also developed by another scholar called Carol something I'm forgetting their second name. So this was developed by Carol and in this theory, they talk about challenging the idea that legal reasoning must always be abstract and detached, and it emphasizes the care, relationships, and context. And they are often values and often associated with women's social roles in the society. And this approach has influenced the family law and even child custody decisions in the society, because the emphasis is on women's role, the care, the relationship, and such context in the society. The very important point around intersectionality. So this term intersectionality has been introduced in 90s by Kimberly Crenshaw. And Kimberly Crenshaw reminds us that gender never operates alone. And Kimberly Crenshaw, who coined this term intersectionality, gives some example around giving the experiences of some women. If a woman is a Muslim woman, a queer woman, a Dalit woman, these women may face forms of discrimination that cannot be understood through gender alone. For example, a queer women, a Muslim women may face discrimination based on their religion, then based on their gender identity. So they face dual discrimination in the society. Workplace protection may still exist on paper, but these sort of religious marginalization, it can prevent access to remedies for these women. So this concept of intersectionality, it sort of pushes us to ask some questions around which women are protected by the law and which women are left out, right? Okay, so now moving on to my next slide, which is about comparing and discussing this concept of gender and law under different separate laws that we have. So herein I have some points around gender and employment law, then gender and criminal law, and also around gender and family law. So first, let's talk about gender and family law. So here in criminal law, it plays a very important critical role in responding to all sort of gender-based violence, including sexual assault, including domestic violence, all forms of gender-based violence. However, the feminist scholars have long pointed out that criminal justice system often sometimes reproduces the gender bias in the wording of the laws, because traditional rape laws, it focuses on physical resistance and implying that real victim must fight back. And this ignored the fear, coercion, and power imbalance. Although we have the consent standards that have evolved, and survivors, they still face that victim blaming thing. They still face the invasive questioning and even social stigma in the society. And then we have the domestic violence laws that recognizes the abuse beyond physical harm in the society, that includes the emotional and economic violence. Yet, when it comes to implementation, challenges remain. And when I talk about the challenges in implementation, that includes lack of awareness, that includes police reluctance, and even social pressure to preserve family unity at all cost. And this shows that how legal reform must address not only statutes, but also institutional attitudes and cultural norms in the society if they really want to make a change. Now, moving on to this gender and family law. So, this concept of gender and family law. So, herein, family law governs some of the important aspect of life that includes marriage, divorce, custody, maintenance, and gender plays very important role here because family structures are deeply shaped by social norms about caregiving, about authority, about dependency. And in many cases, women are expected to be the primary caregivers, and that affects the custody decision and economic outcomes after having divorce in divorce situation. Although courts they have increasingly recognizes women's uh, unpaid domestic care work, but it is still undervalued in maintenance and in property settlements because how to measure that thing, that is a big question. So in Indian system of personal laws, that adds the another layer of complexity, I would say, that different religious communities are governed by different family laws, and that raises questions about equality reforms and legal pluralism. And tensions often arises between constitutional principles and customary practices, and which one to prevail. And this gender analysis help us see that the family matters are these private affairs, these private family matters, I would say, are deeply now converted to legal and political, and that justice within the family is inseparable from the broader gender equality concept, if I have to frame that way in words. So, the other thing is about this concept of gender and employment law. So, employment law is one of the, I would say, clear area where gender inequality, we can say it is visible. The example that I've given in our discussion in other slides about full-time work, and globally and even in India, women earn less than men on average even when performing the similar work. So this wage gap internationally and even in India, this wage gap is shaped by occupational segregation. It is undervaluation of feminized work and career interruptions due to caregiving responsibilities. And this, again, the unpaid care work is major issue here and recognizes the paid labor. But law again largely ignores the domestic work, which disproportionately falls on women. And this affects their promotions, this affects their pension rights, and even long term economic insecurity. So, this thing, and though we have the legal standings here, we have the laws here for their protection about the Maternity Benefits Act, we have the Prevention of Sexual Harassment Act, which addresses the workplace sexual harassment. So while these laws, obviously there is progress, these laws represents the progress, and enforcement, it still remains uneven. And informal sector workers, they often fall outside of the effective protection of these laws. And this sort of illustrates a key gender law insights that legal rights without institutional support and cultural change, it often remains symbolic rather than becoming a transformative thing. Now I will move on to the next slide, in which we'll focus on some of the contemporary legal debates, and we'll also talk about gender law and transitional context. So, in here, talking about the gender law and transitional context. So, herein, in post conflict and transitional societies, gender harm are often invisible in legal processes, and women may experience sexual violence, they may experience displacement and even economic exclusion. Yet peace negotiation and truth commissions, they frequently prioritizes the political stability over the gender justice. And there are scholars in this area, the feminist legal scholars, they argue that this transitional justice mechanism, it often treats women as victims rather than agents. And this treatment, it limits their participation in rebuilding the legal systems. And this gender sensitive reforms, it requires the recognition of sexual violence as a serious legal harm and ensuring that women's participation is decision making is there. And this perspective in the transitional society is important even outside the conflict zones. This is, I'm talking about the post conflict area, the early time wherein feminist legal scholars have just tried to develop the thoughts around this. And even outside the conflict zone, it sort of highlights that how law prioritizes certain harms while ignoring the others in such situations. And the contemporary legal debates around gender and law, they remain highly contested field even today. Reproductive rights debates. Right now, it illustrates the tension between the individuals who have bodily autonomy and state control over the bodily autonomy. And globally, the abortion laws, it reflects the political, religious, and cultural struggles over gender and sexuality, even in today's time. And this specific thing about LGBTQ plus rights, it represents the another critical areas where legal recognition of gender identity, same-sex relationship, and protection from discrimination, it challenges the traditional legal categories. And the positive step by India as decriminalization of 377, it marked a significant shift. But right now, also, full equality remains finished for the LGBTQ plus community in India. Because recently, I am not sure if you are aware, there was a judgment of Supriyo Chakrabarti versus Union of India, in which they have filed a petition, um, in which they have mentioned like the same-sex marriage rights being granted to them, adoption rights, and it is also around guardianship rights, wherein the Supreme Court of India was not convinced with this, and they have said that it is going to be a huge shift. Right now, Indian society is not ready to have accepting that change. So they have denied the petition, but they have also said that maybe not right now, but maybe in future they do not know whether they're going to make such change. But right now, Indian society is not mature enough to accept such change because that requires a huge modification in the personal laws. And we are not ready for that as of yet. But what future holds, we cannot comment on that. So, herein also, if I look at the comparative perspectives from Canada, Canada recognizes the gender identity. Canada allows the same sex marriage for the LGBTQ plus community since 2005. There is specific law that talks about the same sex marriage, the Same Sex Marriage Act. And it helps illustrates that how legal system it can evolve while also highlighting the ongoing resistance that is there in the society, even if the laws are reforming. But we also have to look at the social structure to see if our society is ready for this specific change to happen. Okay, so moving on to the next slide, in which I have mentioned some points around gender, culture, and Indian knowledge system, wherein I'll be talking about dharma, justice, and ethics. Briefly, I'll be touching on these pointers. So, engaging with this concept of Indian knowledge system, uh, it requires a careful balance because the concepts such as dharma, justice, and even community care, it offers valuable ethical insights. But it but it has also been used historically to justify hierarchical gender roles. So a gender sensitive legal approach does not reject tradition outrightly, but it critically examines that how culture values and interpreted cultural values are going to be interpreted, and then those are going to be applied. So the key question is whether tradition is being used to promote dignity and equality, or it is there to preserve control and exclusion. And law must navigate this thing thoughtfully, ensuring that respect for culture does not going to come at the cost of constitutional values and human rights in the society. So law needs to navigate that thing. Yeah, so that's where I have mentioned about this question about how law can respect culture without legitimizing inequality. So law needs to sort of create a balance that respect for culture doesn't come around the cost of our constitutional values, the cost of our human rights, the cost of our laws. I have an activity to do in our next slide. I am not sure if we have time for this because I want to keep some time for the Q&As.
We,
So,
Lovepreet, we can engage the audience in this. That's very
okay.
nice, thoughtful of.
Yeah, I just thought that maybe I can include a scenario, then we can have some discussion questions around this scenario. It's a quick one because I think we have briefly touched on this very thing in one of my previous slides, discussion around those. So I'll read the scenario. It says that a company introduces a policy that all employees must work 9 a.m. to 6 p.m., 5 days a week to be eligible for promotions. There is no flexibility. Everyone is treated equally under this rule. So, herein we have some discussion questions like who might be advantaged or disadvantaged by this policy? How could gender, caregiving responsibilities, or social roles affect the outcome? And can the law be considered fair even if it appears neutral? So, that is again juggling substantive equality versus formal equality. And I'll open the floor for discussion. You can raise your hand and I can call on your name. And again, there is no right or wrong observation. All observations are welcome.
Participants, you are requested to raise your hands and pose your question, your observations. And I really appreciate Dr. Lovepreet's effort in having, formulated this, and it's very relevant. In fact, what was going on in my mind while I was listening to you, that even we are going to open up one activity based on all the talks given by the resource person. You will be writing a blog on any of the topic that has been dealt with by the resource person. So let's begin it today with this activity, because this is a capacity building program and it makes more sense in engaging ourselves in such activities.
I agree, ma'am, because that's what my thoughts were around this when I thought that having something not too complicated, but have something as an activity.
So we can have yeah, Rama Kulkarni, Gursandesh, you can just have this.
Yes. Okay. Rama Kulkarni,
Yeah,
your
hi.
presentation is
Yeah, can you hear me?
Yes, I can hear
yes,
All
you.
right.
I'm audible.
All right. Yeah, hi. Good morning, all of you. So, keeping in mind the first question, who might be advantaged or disadvantaged by this policy, actually reminds me of Indira Nui's experience, where she said that the biological clock and the professional clock typically clash as far as women are concerned, right? And the laws being made, I mean, as far as the time stamp, 9 to 6, exactly the point where in the initial stages, clashes with the nurturing and upbringing of the family, right? There's a lot of stress in that case. And of course, I mean, unless you have understanding and equality, maybe in the family, I don't know how fair or advantage it would be for women, right?
Yeah, yes,
Um,
I agree.
and yeah, and immediately, I mean, how could gender, caregiving responsibilities, or social roles affect outcomes? It's more or less the same thing as I said, because the biological clock and, so I mean, I realize that we are deviating a little bit, from the legal aspect of it. But keeping in mind maybe the role that a woman has to play, as far as gender is concerned, I personally feel that it's definitely not an advantage per se. Um, and yeah. I mean, of course, yeah. This is where women are placed in a family as such. Okay, and can the law be considered fair? Even if it appears neutral, it doesn't appear neutral. It appears to be fair. It is the interpretation, I guess, that matters. And I think one needs to read in between the line. The minute I see 9 to 6, I can feel the pressure on myself. Whereas I'm sorry, I'm not gender biased or a sexist. Guys, please do not misunderstand. But the fact that it's an escape route for the other gender, isn't that so? Um, well, I guess that's my 2 pence on all the three questions. Thank you so much. This is really interesting. Thanks a lot.
Thank you. Thank you so much for the observation. And I agree completely with your thoughts around there. And when you say that it appears gendered, though, but it doesn't appear to be neutral, um, um, I would say that herein the example itself is like neutral in a way, like it is applicable to all the genders equally in that sense. That is why
Okay.
I Yes, that is why I've used the word neutral there. So yeah, otherwise, all the observation that you've shared there, I completely agree with that, and that is what my I would say expectation from the participants is. And but really, thank you so much for jumping in and sharing your thoughts. I really appreciate that.
Thanks a lot. I mean, pleasure. Yeah.
Yeah.
I'm a working woman, so obviously these things, my eyes would be fixed on 9 to 6.
Yeah. Thanks again.
Yeah.
That's really interesting. Thank you, Dr. Rama, for your observations, and thank you, Dr. Lovepreet, for having had this on your slides. It makes more sense, right?
Yeah.
Um, I just was really wondering whether, because like you talked about the Indian context, you talked about the Canadian context, right? So
Yeah.
how do you think, because you have been a student of law here in India, and you are now teaching law there in Canada. So what kind of a comparison, do you find, like the law on paper and the law in practice, with respect to the activity that you have, taken now in this session?
That's a really interesting question, ma'am. Thank you so much. That is making me think on my thoughts in here. Okay, so teaching law in Canada, or teaching subjects around gender justice, I would say, uh, and making talking about contrasting between law on paper and law in practice. On paper, I would say Canadian law, it offers, I don't want to say, because in Indian law also we have gender protections, but I would say implementation wise, I would say they offers the strong gender protections. If I look at the implementation side, the constitutional equality under the Canadian Charter that explicitly recognizes the gender identity and expression. When we say that, we also do have that. But when it comes to implementation, that is where the challenges exist. So the robust human rights legislation, it exists on paper here in Canada, and it's very much exists in practice as well. And when I compare that with India, even if we look at the LGBTQ plus, the long battle that this community has fought to achieve that basic equality that other genders have, though we have the Article 14 from the very beginning, since the implementation of the Constitution there, still they have this long battle to achieve that equality and getting at par with the other gender, being recognized as the other gender. And that also has taken so long for them that they get this equality and being recognized and being called as a third gender in the society. So having said that, I would say that steadily the change is happening, steadily things are progressing. Implementation has been done in some of the contexts, but in both India and Canada, so transforming the legal commitments to lived equality. And the difference, it mainly lies in the mechanism of enforcement and institutional accountability, not in what we can say where the gaps are.
Thank you so much. Thank you. We can proceed.
Yeah. Thank you so much, ma'am. We have a comment. Therein, unfortunately, law in paper is law in paper in India in some cases. Yeah, I would say that. Yeah, because in some situation, I don't want to say and use the words that this country is being progressing, but I would say that I have studied law in India, and again, we have laws. We have everything. We have the wording that says everyone being treated equal in the eyes of law. We have such things. But again, the implementation part, whether that neutrality is actually doing the justice, that question mark still needs to be answered. So, yeah. So I will move on to I would say the last slide. This is the last slide that talks about the key takeaways and some of the reflection questions again for our discussion today. So to conclude our discussion, I would say that gender in law, as I have mentioned at the beginning of our discussion, that it teaches us that legal systems are not neutral, and equality itself requires more than identical treatment. It requires attention to power, it requires attention to context, lived experience, and gender intersects with other form of inequality, and making the intersectional analysis, as I said, a very essential element. And law can be a powerful tool for social change, but only if it critically examined and effectively implemented in the society. And now I would invite you to reflect on again some few questions around These are the few questions that I have planned, like formal or substantive equality. What do you think? Which works better? And how should law engage with tradition and culture? And can legal reform drive social change? So these were my reflection question. And other than these, if you have any questions in mind, please feel free to put them in chat, or you can raise hand and ask those.
Thank you, Dr. Lovepreet. It was a lovely presentation
Thank
and
you.
very well structured and balanced to the most. And I think you have really hit the bull's eye by posing those questions and making again these reflection questions a part of your presentation. So, if at all we have any questions, though we were discussing a lot the activity that ma'am engaged us in, if we have any questions, kindly raise your hands. Mr. Gursandesh Singh is going to facilitate those. And there is a
Yes,
Google
ma'am.
form, feedback form, which you need to fill out. Also, a request to just switch on your videos so that we can capture the moment. And Laprit, we can have that slide, the initial one, the reflection points,
Okay.
so that we can even include that. Yes.
Okay, ma'am.
And this should, I mean, give you some food for thought to compose your blog as well if you are interested in penning down a blog on gender and law today, right? So maybe after the concluding lecture, that is on 23rd, we might give you some time till 25th of December. You can submit your 25th or 26th of December, you can submit the blogs, which we will publish on our website. Dr. Gaurav, you're going to do this for us, right?
Ma'am, the one thing I didn't ask the audience, is it all the faculty or we have students?
This is a mixed audience, and if we at all we have research scholars, because Dr. Lovepreet has worked on the LGBTQ rights, and I mean this is a wonderful opportunity because the purpose of the Center of Gender and Cultural Studies at Jagat Guru Nanak Dev Punjab State Open University, and primarily this capacity building program is research dissemination, right? So we are trying to disseminate research as much as we can, because yesterday we had Dr. Priyam. She has worked on an intersection of gender, disability, and media. Likewise, ma'am has a different field which she has taken up, and many of you might be researching on it. So you can please, if you have any questions, don't miss the opportunity.
And later on as well, if you have any question, you can get my email from ma'am, and please feel free to just send me your question, or if you want to have discussion on anything related to LGBTQ plus community or anything related to human rights or gender justice.
Lovepreet, I saw Vaishnavi had also joined. Vaishnavi, are you there? If you remember,
Yes, ma'am.
yes,
I'm there.
Vaishnavi, Vaishnavi, do you have any observations? Would you like to have a dialogue with Dr. Lovepreet? We appreciate your presence, Vaishnavi. We appreciate. So, if we don't have any questions, we can call this a day, Gursandesh and Mr. Gursandesh. Mr. Monjit, have you just taken the picture of the day today? Photograph has been taken?
Yes, ma'am. Yes.
Okay. He has been
Ma'am, can you
resharing.
send me feedback forms on the mail as I'm not able to open it on the chat?
Vaishnavi, we definitely will share it with you. Mohanjit, please note kar lijiye. Vaishnavi
Ma'am,
ko.
actually, the link is not a hyperlink. Na? That is why we're not able to copy or go through that particular link. We have to type that particular web page address. So it's becoming little difficult for us.
No problem. Monjit, just give 2-3 seconds. Just stay on in the session. He'll work on it and do the needful. Meanwhile,
It
Mr.
was a
Kusumesh,
wonderful session, ma'am. Thanks for imparting us with the wonderful knowledge.
thank you so much, Vaishnavi. It's always a pleasure. Always a pleasure.
Thank you so much, Vaishnavi.
Mohanjit is going to reshare the feedback link with you, form with you, and Mr. Gursandesh can pick on from here for uh, the fag end of the session. Right.
Thank you, ma'am. Thank you so much, Dr. Lovepreet, for this session, for your talk. Uh, it was enlightening for, I'm sure, all of our participants, but it was for me, definitely. Like a few things that you discussed, like the personal issues are political and legal rights. They cannot be enforced without institutional support and cultural change. And the reflection question: can legal reform drive social change? It's like it, uh, Rico has a lot of thinking. Like for me, I've been thinking about how for a while it felt like till the middle of 2000s that 2010s that things were getting progressive, but with the global rise of fascism and everything, like even a like nation like America, which they got the LGBTQ, the same-sex marriage also, and but now they're in a position where even abortion is banned there. So even like there could be arguments made both for and against legal reform driving social change. It's very interesting. Thank you, ma'am, for raising so many questions and all these issues. I now request Dr. Gaurav to present the formal vote of thanks.
Thank you so much, sir, and thank you, ma'am. Also, it's very energetic lecture. So, on behalf of Jagat Guru Nanak Dev Punjab State Open University, Patiala, I extend the formal vote of thanks. We have, first of all, we are deeply thankful to our worthy Vice Chancellor, Professor Dr. Ratan Singh Ji, and for his visionary leadership, his guidance, and constant support for inspiring the meaningful initiative in teaching and research at the university. Right. We also express our heartfelt gratitude and appreciation to our expert, Dr. Lovepreet Kaur from Brock University, Canada, for delivering such an energetic and innovative lecture on gender and law. So specially focused on working women and LGBT plus community for their rights and justice. So thank you so much, ma'am. And my sincere thanks to our worthy Dean Research, ma'am, Dr. Navleen Mutalni ji, whose continuous and dedicated efforts on organizing these type of academic programs, which enhance the university reputation, research culture, and academic engagement. And many thankful to Mr. Gursandesh Singh and Mr. Mohanjit Singh ji for their efforts and support. And finally, we thanks to all the participants for their involvement and kind cooperation. So thank you everybody.
Thank you once again. Thank you all of. Thanks.
Thank you so much,
We
ma'am.
we will connect sometime again, Dr. Lovepreet, as I told you, for the IKS
Yes, ma'am.
conference.
Yes, ma'am. I know we've been initially talking about that, so I've just tried to have that component also in the presentation.
Yeah.
Yes.
So thoughtful.
Yes.
So everyone have a good day and a good night, Dr. Lovepreet, as it's quite late night there in Canada. Thank you so much for your time.
Thank you so much, ma'am, for inviting me, and it's a great opportunity for me as well.
Thank you so much, ma'am.